Welcome back. After failing to sit for the better part of last week owing to a training for some selected judges, the courts across the country dealt with a massive workload of cases. We're tracking some of the top stories for you, and here is a recap.
We begin with the report that the Court of Appeal sitting in Abuja on Tuesday, November 14, reserved its judgment in an appeal filed by the federal government challenging the dismissal of the 18-count charge it preferred against the Senate President, Dr. Bukola Saraki, before the Code of Conduct Tribunal. A three-man panel of the justices of the appeal court, led by Justice Chinuade Akomolafe Wilson, adjourned to decide whether the case against Saraki should be reopened or not. The federal government had, in its 11 grounds of appeal, prayed the appellate court to set aside the CCT verdict that acquitted Saraki of all the charges it brought against him. It wants the court to direct Saraki to enter his defense to the 18-count charge. Staying in Abuja, a federal high court has fixed January the 17th, 2018 to decide if it will set aside the order of proscription against the indigenous people of Biafra, IPOB, as a terrorist group. IPOB had earlier asked the court to reverse its orders, proscribing it and labeling it as a terrorist group. In September 2017, IPOB made the request in a motion filed by its lawyer before the acting chief judge of the Federal High Court, Justice Abdul Kafarati. The group made this application barely 48 hours after Justice Kafarati had granted an ex parte application by the Attorney General of the Federation and Minister of Justice, Abubakar Malami, for the proscription of the group and its categorization as a terrorist group. IPOB has always insisted that it is a non-violent movement. Another federal high court in Abuja has dismissed a motion by the detained former National Security Advisor, retired Colonel Sambo Dasuki, seeking an order to suspend and adjourn indefinitely his trial on charges of illegal possession of firearms and money laundering. In his ruling, Justice Ahmed Mohammed held that Dasuki's application was misconceived and lacked merit. Dasuki's counsel, Senior Advocate of Nigeria, Mr. Ahmed Raji, had, at the hearing of his client's application on October the 17th, asked the court to adjourn the trial indefinitely pending the hearing and determination of the ex-NSA's motion for stay of proceedings filed before the Court of Appeal, Abuja. The prosecuting counsel, Senior Advocate of Nigeria, Dikbo Okpesheyi, had, however, described the application as an abuse of court process. And in Lagos, a justice of the Federal High Court, Justice Hailadzira Ngajinwa, who is charged with collecting bribes to pervert the course of justice, has alleged bias against the court where he is being tried. On the 23rd of June, the Economic and Financial Crimes Commission had arraigned Justice Ngajinwa for alleged unlawful enrichment to the tune of $260,000 and 8.65 million naira. The commission said the sums did not correspond with the judge's salary. They also claimed that the judge could not explain the source of the funds. Justice Ngajinwa, who is attached to the Bayelsa Division of the Federal High Court, has however told the court that he had written a letter to the administrative judge of the Lagos High Court seeking a transfer of the matter to another judge. He accused the trial judge of bias in favor of the prosecution. The EFCC prosecutor, Mr. Wahab Shitu, has described the allegations of bias as an attempt to frustrate the trial. He has also argued that there was no way the matter involving Mr. Ricky Tafa can influence Justice Ngajinwa's matter before the court. Justice Akintoye has reserved ruling on the issue till November the 22nd. And we round off with the report that the EFCC has given an indication that it will amend the 450 million naira money laundering charge against a senior advocate of Nigeria, Dele Belgore, and a former Minister of National Planning, Professor Abubakar Sulaiman. Counsel to the Commission, Rotimi Oyedepo, gave this hint at the continuation of the trial against both men. Mr. Belgore and Professor Sulaiman are standing trial before the court for allegedly conspiring with the former Minister of Petroleum Resources, Mrs. Diezani Alison Madueke, to launder 450 million naira. At the last sitting of the court, an EFCC investigator, Usman Zakari, who answered questions of the defense team, restated his earlier testimony that both men had admitted during investigations that they collected the 450 million naira. He testified that the senior advocate of Nigeria, Mr. Belgore, who contested the last governorship elections in Kwara State, had particularly admitted that he disbursed the money. The defense team was, however, quick to point out that this piece of testimony was not contained in the witness statement upon the conclusion of his investigation into the matter. This perhaps prompted the EFCC to hint of its readiness to amend the charges against the two defendants. Further hearing in the trial has been adjourned to November the 24th.